Good news from Arcelor as the National Company Law Appellate Tribunal approved their 42,000 crore rupee resolution plan. However, it was not good news for the Committee of Creditors for Essar Steel. Why is that? Well, Payaswini Upadhyay has the answer.
Well, the NCLAT order brings good news for ArcelorMittal, but not so much for Essar Steel's creditors committee and, well, creditor committees in general, which usually consist of financial creditors. And I'll come to why in just a bit, because besides deciding on the eligibility of ArcelorMittal's plan, the NCLAT had to also determine in this case the allocation of funds between financial and operational creditors of Essar Steel. The NCLAT concluded that the allocation approved by Essar Steel Creditors Committee was unfair and discriminatory. The NCLAT has gone a step further to say that Creditors Committee have no role to play in the distribution or allocation of funds to various creditors. The allocation the NCLAT has held can only be suggested by resolution applicants, and if this allocation is found to be discriminatory, it's open to judicial review. The NCLAT hasn't stopped here. It has also more importantly held that there is no distinction between different kinds of financial creditors. When I say different kinds of financial creditors, I mean secured and unsecured financial creditors. And lastly, the NCLAT has said that there is no distinction even between financial and operational creditors of a corporate debtor at the resolution plan stage. Now, let me point out the IBC lays down a waterfall or a hierarchy under Section 53, based on which allocations or priority is given to different kinds of creditors, whether it's secured, unsecured, workmen, employees of the corporate debtor. The NCLAT has said that this waterfall needs to be applied to the liquidation stage, and there is no reason why any distinction needs to be drawn between different kinds of creditors at the resolution plan stage. In terms of implications, experts say that this has turned the credit hierarchy, as they understood it so far under IBC, on its head. It will remove the distinction between, let's say, a creditor which has been wise enough to lend only to the extent of its security versus a creditor who has just lent to a stressed asset or a corporate debtor without taking due cover in terms of security. The second important implication of this is that if a secured creditor has to realize that at the resolution plan stage, it's going to be treated on a par with an operational creditor or an unsecured financial creditor, experts fear that they might start rejecting resolution plans because they'll realize that at the liquidation stage, they can that distinction will come alive, and they can very well use that security to maybe perhaps get a better claim. Now, all of this will be further clarified by the Supreme Court because Essar Steel's Creditors Committee has decided to appeal it in the coming days.